Left unanswered and emblematic of the conflict that compels his disqualification is whether Mr. Cosgrove is A, expressing his personal opinion about Ms. G's credibility and criminal exposure in the event her testimony favors Mr. Carney, or whether he speaks for the public as a representative of the Commonwealth. Of course, this wouldn't be an open question if the Commonwealth had the wherewithal to have its response to a disqualification motion drafted by someone other than the prosecutor who is the subject of the application and whose response includes his personal opinion that the witness suing him likely will perjure herself if she testifies at trial. Either way, the conflict is undeniable. Mr. Cosgrove personally benefits in the civil case by discrediting Ms. Gaetani in the criminal case, which means his continued participation in this matter will lessen, here we go, the public confidence in the integrity of the prosecution. Now, it's almost to the point of irony, well, funny, because nobody has any confidence. Therefore, how can it be hurt any further? Carry on. Nor should the irony of Mr. Cosgrove's comments about Ms. Gaetani's credibility be lost on the court. A civil defendant, prosecutor, with a clear personal motive to discredit his accuser and or prevent her from testifying, issued her a public perjury warning in a case where he will argue to the jury that Mr. Carney attempted to intimidate witnesses by, among other things, urging them to, quote, tell the truth. The case against Mr. Carney is a high-profile matter of public concern, which raises serious issues regarding the intersection of protected speech, big fan of that, and alleged witness intimidation. Mr. Carney and the public are entitled to a conflict-free, unbiased proceeding in which he and the public have confidence. This case cannot credibly proceed in its current posture. Mr. Cosgrove's personal interest in discrediting Ms. G conflicts with Mr. Carney's, the Commonwealth's, and the public's interest in fair and just legal proceedings. What, did I miss a footnote? I sure did, doggone it. Back up there at 7, I see it right there, tell the truth. Given the Commonwealth's broad interpretation of the intent and emotional injury elements, oh boy, don't get me started on that. This is the statute where you hurt your feelings, you've got a case. Who knows if Ms. Gaetani, a witness against Mr. Cosgrove, will allege that public statements by a powerful prosecutor defendant warning her about criminal exposure if she testifies constitutes witness intimidation of her by the adverse party in her lawsuit. So Cosgrove might be intimidating Lindsay G by telling her that testifying could lead to some sort of criminal matter for perjury. So he's doing that just to intimidate her, to keep her from testifying? Curious. Curiouser and curiouser. This case cannot credibly proceed in the current posture. Mr. Cosgrove's personal interest in discrediting Ms. Gaetani conflicts with Mr. Carney's, the Commonwealth, and the public's interest in the fair and just legal proceedings, and compels his DQ for the exact reason Mr. Cosgrove voluntarily withdrew from the 2024 indictment. These guys are just like a dog with a bone, and they just, as many times as you give them an exit, they clamp down harder. So, I mean, mixed metaphors there on the dog and the bone and an exit. It is fundamentally unfair to permit a district attorney to prosecute a case where he has a personal interest, which prevents the district attorney from serving his only permissible master, the public. That's a great quote in this Dunlop case. So some more quotes there, case law quotes, notwithstanding, I'm going to skip down here, notwithstanding his personal interest in discrediting Ms. Gaetani due to her allegations of misconduct against him, Mr. Cosgrove reasons that the same conflict that led him to voluntarily withdraw in the 2024 indictment does not require his DQ here because Ms. Gaetani is not a necessary Commonwealth witness, and B, any testimony she might provide is not relevant. He is wrong. Why? Well, moving on. A defendant has a constitutional right to attack a witness's credibility by establishing that witness's bias and motive to falsely accuse him. This is Hornbook law. Black's Law Dictionary, look up bias, look up motive. These are just classic examples of how you would, in your Sixth Amendment right to confront witnesses against you, you get to use all these tools. And you can't just say they don't exist because they kind of get in the way of your argument as no conflict. They exist. There is a conflict. Assuming, arguendo, that Mr. Cosgrove does not That's one of the first words you'll learn in law school. You go, what the hell is that? I mean, basically, it's, for the sake of argument. Assuming, for the sake of argument, that Mr. Cosgrove does not call Ms. Gaetani as a witness and that her testimony would not be relevant to the substance of the indicted charges, Ms. Gaetani's testimony will undermine the credibility of key prosecution witnesses, Tully, McCabe, possibly others, citing to the Bederow affidavits of October and November. In addition to being examined about these issues that adversely impact Ms. McCabe's credibility and D.L. Tully's possible tampering with her cell phone, is another aside, Ms. Gaetani may be questioned about separate civil allegations pending against Tully in 2 lawsuits. Okay, let's get that. The court has discretion to decide whether D.L. Tully's credibility is a critical issue and whether his alleged conduct is admissible in the interest of justice. So just kind of a broad swipe at Tully based on what's going on with this dude. 2 other lawsuits in which he's involved. In any scenario in which Mr. Cosgrove examines these witnesses and or comments on their credibility, fundamental fairness requires that the jury be made aware that the prosecutor addressing it, the jury, has a personal interest in discrediting Ms. Gaetani and crediting those whose credibility is damaged by Ms. Gaetani. But such a scenario would expose the jury to Mr. Cosgrove's conflict of interest. I can't even imagine a jury taking that in and not immediately common sense saying, really? How is this guy playing both sides of the fence here? The proper remedy is to ensure that another disinterested prosecutor, if there is one, conduct these examinations and address the credibility of these witnesses. It is axiomatic that an individual prosecutor cannot prosecute a case in which his personal interests differ from those of the Commonwealth, where there is a significant risk that an individual prosecutor's representations of the Commonwealth in a specific matter will be materially limited by the lawyer's personal interest. The prosecutor shall not represent the Commonwealth in the case. Part of what you're also doing to the court here, again, give the court everything they need to decide in your favor. They got to have the law. Facts and the law will come to a decision. The facts he's laying out clearly and almost laughingly, they're abundantly clear and proving conflict. Okay. So to what end? Well, here's the law that says what you got to do. And key to legal language, both in statutes and in common law, shall not is directive. Okay. It's not may not, it's shall not. And that lays down the law that a court should follow. Further citations. Here, Mr. Cosgrove's personal interest in seeing Ms. Gaetani discredited differs from the Commonwealth's interest, which in every case is to see that justice is done. Again, more general platitudes about how does a guy who's supposed to be pursuing justice for the Commonwealth and is so obviously conflicted, how does he continue? I'm going to skip a lot of those. More cites. Oh, this is fun here. Ms. Gaetani has alleged that she was pressured to cooperate with Ms. McCabe. She has claimed that Ms. McCabe provided benefits to Catherine Peter, another of those names coming up out of the dredge. And of course, Aiden has a number of nicknames for virtually all these players. She has asserted that Ms. McCabe has voodoo dolls of Mr. Carney and Ms. Reed in her home. She was told by Catherine Peter that Ms. McCabe was worried about the disclosure of text messages between her, Carrie Roberts, liar, which revealed what a few days after John O'Keefe's death, they discussed who would play them in a movie. Oh, God. Obsessed with yourself much? On December 20, 2025, footnote 9 says, Ms. Roberts publicly claimed that she and Ms. McCabe joked about Sandra Bullock coming out of retirement because they needed her. Ms. Roberts also said that they determined Ms. McCabe was Angelina, presumably Angelina Jolie, and that we even had an actor in mind to play Mr. O'Keefe in a movie. So, delusion, it's a powerful thing. Not just about the movie, but who they think should play them. Anyway, where was that foot? There we go. It is the Commonwealth's interest to investigate these claims because if they are true, Ms. McCabe's credibility will be undermined. Do you think? Is that possible? Ms. Gaetani will testify that D.L. Tully intentionally mishandled her cell phone. by tampering with and or deleting its contents. D.L. Tully will deny this. Mr. Cosgrove has accepted D.L. Tully's explanation without any further investigation. Clearly, these issues are relevant to D.L. Tully's credibility, and the jury should not be ignorant to the fact that the prosecutor addressing it, the jury, has a personal interest in favoring D.L. Tully over Ms. Gaetani because he was sued by Ms. Gaetani and is D.L. Tully's co-defendant. You start to think when you're preparing these materials, how many times can I beat the court over the head with these very obvious conflicts? And to me, the answer is generally not enough times. Yeah, because if you leave it off the page and assume certain things, I think you're going to go sideways. Yeah. Sideways meaning the court won't help you. As is the case with evidence regarding Ms. McCabe's credibility, it is the Commonwealth's interest to determine whether Ms. G. allegations against D.L. Tully are true. But it is in Mr. Cosgrove's personal interest to simply credit Ms. McCabe and his co-defendant, D.L. Tully, and to discredit Ms. G. Moreover, Mr. Cosgrove is incapable of acting in the Commonwealth's interest regarding Ms. G.'s allegations because he cannot directly engage his accuser. In any event, it is hard to fathom why Ms. G. would agree to speak to Mr. Cosgrove about these issues given their present legal entanglement. Yeah, I don't know who Ms. G's attorney is. She had one on and off, but that puts them in a weird position as well. The bottom line is that any scenario in which Mr. Cosgrove argues in support of D.L. Tully's credibility and or against Ms. G's credibility serves his personal interest above all else. There's simply no way around this conflict. Agreed. As described by the D.C. Court of Appeals, Ms. Gaetani's unvetted allegations make it untenable for Mr. Cosgrove to prosecute this case because his personal interest is in discrediting Ms. G is in direct conflict with the Commonwealth's interest in seeking that justice is done and leads to the inescapable conclusion that his participation fails to, quote, preserve the appearance of impartiality in the proceeding. Again, another cite to that. Previously noted, this appearance of impartiality will be further destroyed by Norfolk Spud's failure to recuse itself. Mr. Proctor's biased and disparaging comments about Mr. Carney during the investigation, and evidence of Sergeant Buchanan's lack of impartiality, fundraising efforts, which is one of the new wrinkles, and advocacy on behalf of witnesses against Mr. Carney. Footnote 10, it's a biggie. Sergeant Buchanan's fundraising on the behalf of prosecution witnesses obligates the Commonwealth under Brady, Giglio, Rule 14, to investigate and then disclose any evidence that tends to show that the McCabes and Alberts were offered, sought, expected, or received any possible benefit relating to Sergeant Buchanan's solicitation on their behalf. Good luck with that. Good luck proving that he's squeaky clean, even though he's out there, he's huckstering for them. This includes communications between and among Sergeant Buchanan and the witnesses, and records of money received by the witnesses related to Sergeant Buchanan's request for donations. That's again, I'm always waffling between, are these people just that stupid, that arrogant, or a little of both? In these circumstances, it is improper for a prosecutor to participate in a case where a threat to his personal and professional reputation is created by a bona fide civil lawsuit alleging bad faith in the performance of his official duties. This case, if this recusal is denied, it's perfect for an appeal. And there's tons of case law that would be consistent in a reversal. I just don't know, because that's not cheap. So I'm not sure if that's in the cards, but it's certainly, I think, warranted if that was something that Aidan Carney decided he wanted to do. Oh, footnote 11. This is the exact situation that exists here in light of Ms. Gaetani's allegations against Mr. Cosgrove. 11, Mr. Cosgrove's opinion that Ms. Gaetani's lawsuit will not survive a motion to dismiss doesn't absolve the conflict. The conflict is created by Ms. Gaetani's allegations, which, even if not the subject of an active lawsuit, create the risk of reputational and professional damage to Mr. Cosgrove. So if the Commonwealth says, well, her case blows, it's not even going to survive a motion to dismiss, it's going to be gone, doesn't matter. The conflict exists outside of the lawsuit. The lawsuit brings it all in focus for the court to have to deal with. But the facts in and underlying the lawsuit are still there, even if the lawsuit is dismissed. The conflict is still there. Reversal, that's citing the Cox case, reversed on a finding of conflict where a sincere and conscientious public official would naturally be outraged by alleged defamatory statements, as would any person. And again, that was outside the context of a lawsuit. Accordingly, given the need to promote the appearance of justice, a trial court on a timely motion should disqualify a prosecutor. Blah, blah, blah. Case cite, case cite, case cite. And there are plenty of them, I do believe. Conclusion. For the foregoing reasons, and those stated in the prior defense submissions, the court should disqualify Robert Cosgrove. And then down here it should say, so there. But I don't see that. I don't see that listed here. Certificate of service, blah, blah, blah. So there you go. That's, it's like a bonfire. You know how when you're trying to start a fire, and you start with small things and you add, pretty soon you got logs on there. Oh, my cedar log. Somebody suggested, it's an amazing smell, that I should have this kind of a tribute to the log lady in Twin Peaks. If you know. I may have to go back and start rewatching that because it may have a whole different spin on it these days. Anyway, now you got logs on the bonfire. The thing is, it's a 5-alarm fire, and the conflict is so obvious, it's nauseating. The real question is, as I've said from the very beginning, now every time we get a new judge, we got Judge Crap, we've had Judge, I can't remember the last one. Now we have this new judge, who I'm calling Judge BZ. We've not really seen him show his stuff. I felt he was way soft on them when they had their first Zoom meeting. Because remember Cosgrove, Mr. Diligent Cosgrove, he filed his responsive papers, I think it was 8 days late, with no notice to anybody, to the court, to the defense attorneys, that it was late. And he just shows up in court on the Zoom effectively and says, I got it to you. I got it to you this morning. And the court lets that happen. And that's my problem. There are going to be attorneys everywhere that flout the rules, that bend the rules, and they will continue to do it. And it will continue to get worse until there is a consequence. So far, even from Judge BZ, I've not seen any consequence. Now, he may have been waiting. He may have been, knowing what's bubbling underneath, bringing this recusal motion, pairing it out from the motion to dismiss. He may already know which way he's leaning. And therefore, the late filing of Cosgrove is moot, really, because you're going to go forward with a new attorney, if it's possible. That person's going to get more time to prepare, get up to speed, and meet the motion to dismiss, now set for the 23rd of this month. Which likely will be set some point after the 23rd of this month when the recusal motion is heard. So maybe this judge he's got it all worked out, but I am so jaded at the judges that I have seen in person and on Zoom, just do a horrible job. Not all of them. We have seen a couple along the way that were like, how'd they keep their job? Because they seem to know what they're doing. So the jury is still out on this judge. I'm going to give him the benefit of the doubt. I wasn't happy with the Zoom meeting. I thought he could have been much harder especially on Cosgrove. But if he pulls it out on the 23rd, love to see him make a decision that day. Highly doubt that it's going to happen. But if the decision ultimately is the right one and Cosgrove is out, I'll give him a little breathing room before I consider him a loser. So, all right, that's where we are with that. Let's see what I've got here. I haven't gotten around to doing some of this stuff because I was reading to the class. Lynn of 9600, member for 2 months. Thank you so much. And yes, hit the like button. Somebody mentioned, I was looking at one of the comments, I think it was from yesterday, saying more people should be putting their DNA on the like button. And I said, I never ask. I always forget. I'm just it's not kind of my normal process to pass the hat, which is kind of what it feels like to me. Like, hit the like button because you like us. But I guess in this world, you sort of have to remind people, I guess. So, hey, hit the like button and subscribe and comment and like. Is that everything? Yeah. But thank you for the reminder. I do appreciate that. So, strange credibility. He appears to be leaning to Causey not being recused. Now, I'd love to know a little more about why you get to that conclusion. I felt he was giving him a break in terms of allowing late response. I get that. But I don't know that I felt like, he's trying to help Cause. I really think maybe he kind of sees what's happening down the road, as I just suggested, and he's giving him a little rope to hang himself. I think that could be just a thought. How much bull has to happen with Aiden's cases before a judge realizes how much bull really is and just drops? Yeah, that's. I think you're asking a rhetorical question, because every time we think there's been enough, then there's more. Somebody shovels in a little bit more manure. And again, we have a new judge 2 weeks from, is it 2 weeks from Friday? Yeah, 2 weeks from Friday, which if you're watching this on replay is 2 weeks from last Friday. We'll find out. I can't wait to be up there and check this out. I am not happy that it's actually in downtown Boston now, because it really screws up my travel. The court did not give me any consideration for that. I'll have to go up the night before just so I can get there, even if it's at noon or 2. Getting to Dedham is pretty straight shot, 2.5 hours on a good day, 3 on a bad day. But from there into Boston proper, now you're talking about a mess. So, but it's going to be important. And why are we going there? Some people might, well, why are we going there? Well, that's where the judge is going to be at that time. He does tend to float around, but it's a whole different county. Doesn't change the fact this is venued in Norfolk. We're going up to Suffolk. So I hope you're right and I'm just jaded. Yeah, no, I mean, maybe you're right and I'm just a Pollyanna. I always like to give people the benefit of the doubt. It's just so much harder every time I see what happens in the Triangle of Terror there of Dedham, Stoughton, Canton. Don't mind me while I scroll. While I'm scrolling. Yeah, let me throw this out there. We've had this question a couple of times. Thanks, Love and Life, Emma Love and Life. I have not. I know he made an appearance in one of our shows, I want to say last week. So, again, we believe he's just taking a little time off, which is not a bad idea. There can be some, this can be a weird existence. Oh, great. That's great. Good to hear. And the way this works is when we have people, and I will mention this now, I'll mention it again tonight, that one of our constant contributors, and now I'm gonna forget the name, which I usually remember. I can't remember, but she donated 5 memberships last night, and those then get put out by the YouTube overlords just randomly. So if you are a subscriber, it could just you could wake up and it could be in your stocking. So that's generally the way it works. Okay, you could put it this way. Yes, nobody seems to care. I know it is so frustrating. As I've said, the rules are supposed to be there for a reason, but if nobody's going to enforce them with a consequence, then who cares? And I think until the light of the Karen Reed case and now the related cases, Aidan Carney's, Sandra Birchmore, et cetera, the light being really shown on the system up there, they really were like Mayberry, RFD, like we're just this tiny little town. We got Aunt Bee, we got Otis, the town drunk, we got Barney with one bullet in his pocket. I think they really felt just insulated from the real world. Well, that's over, man. That is over. AJ dropping off because he has integrity. Well, that's, Lori Ballou, 7993. Everybody deserves a defense. It's a heartbreaking case. Again, we're talking about Nick Reiner, who's been accused of the deaths of his mom and dad. AJ jumps in almost immediately, and he said in his press conference, which we'll get into that tonight. If you're watching this on replay last week, he was very interesting. He said, first of all, I can't disclose exactly why, but some issues have arisen, not his fault, not Nick Reiner's fault, that prevent us from continuing representation. And then he says, but I wrote it down. It was such a bold statement. I think I sent it to Linda up in Harvard, because I wanted to keep her up to speed on what was happening, because, Alan is a friend of the show, of course, and a friend of Linda's from their past efforts. Nick Reiner is not guilty of murder. Print that. And he said it in his Alan Jackson way. So it could be a money thing, because we know that there was some discussion that the Reiner family was going to pay his bill, and it would be a big bill. But we don't know if that's true or not. That's not something that's normally disclosed. And if there was some problem with money, like the estate is tied up because family members may or may not have been involved in his death, in the death of the parents, maybe getting paid would be an issue. I don't like to judge somebody suggesting that, hey, I can't get paid, I'm out of here. There are realities in this business. When you see a case like this, it's going to take a dramatic amount of time. And Alan Jackson today said that from the day he got the phone call, which I think he said was on the 15th, it was the day of the arrest was on the 14th, so of December. He said, we've been working on this, nonstop. And you could see some of his support people behind him. Same folks you've seen in the Bohm case out of Pepperdine in the Malibu area in California, and Karen Reed, same support staff. So when his team is on something, it's a team. And he said they've been on it every waking hour since he got that call. Can you imagine what that's 3 weeks of hardcore Alan Jackson team time, and that's a lot of money. So is it a money thing? Don't know. I don't think, though, Lori Ballou 7993, that he just said, even if he thinks this, that he's guilty without excuse, I'm not taking the case. I don't think that's the way any good attorney works. A good attorney knows they have to zealously represent their client one way or the other. And we fully expect this is going to be not guilty or not guilty by the reason of insanity. That's where it's going. He does have a new public defender, which leads you to the money question again. Her name is Kimberly Green. And again, on the replay, this will be old news, but she was just appointed today, been at it for 19 years in the California system there. And we'll see what happens. I give Alan, more than I would give most, the benefit of the doubt that I don't think he's just money grubbing. And I think there may be a conflict that has something to do with other than money. Donnie, not Wahlberg. Okay. Well, try to make it on time next time. You'll have to do some extra homework. Doolin, thank you. Yeah, I can't keep all the judges straight. Doolin was one of the guys that drove me crazy. He said, be there. If you're in court, you can tell so much more about what's happening, because when they drift off to their little sidebars, even if it's being streamed, they go off to the fan, or they go off to the clock or whatever. But if you're there in court, you really can hear something. Cosgrove, Jackson. And more than that, you can see the judge interacting. And Doolin is just a jokester. Just they could be in the midst of the most outrageous issue, dealing with, literally life and death. And he's yucking it up with his buddies, because it's a very insular legal community. And that's true in most communities. You have folks that parachute in, like an Alec Jackson comes in from across the country. But generally, these are all folks that work together all the time. Some of them are from like the public defender's office that then work privately after that. And then there's a big, it's very incestuous. But I think it's inappropriate for the judge to be yucking it up with the folks on sidebar on these issues that their clients, the defendants, in whatever case it might be, they don't appreciate that. This is not funny for them. And I've seen them do it, Doolin, with people facing drug charges, people facing assault charges. And it's just all fun and games for Doolin. So I'm glad he's gone. I liked him at first, and then I saw that happening at sidebars. I said, I don't like that. I don't like it. I don't like it anymore. Okay, I think, let me throw this in there, Donnie, not Wahlberg. Thank you so much. 9 months. That is great. We appreciate that. That is quite the commitment. You are committed. And I mean that in a good way. All right, so we're going to wrap this up. We know now what's going to happen. There's going to be another filing. Cosgrove is going to file his sur-opposition or sur-response or whatever he wants to call it in his caption, and it's going to be a doozy. The court has already said we're going to limit, enough with this paperwork back and forth, but it would probably be appropriate to allow a response to this if there's going to be one. And we'll find out. On the 23rd, we will be there with, what do they say? My mom used to say, with bells on. I'm not quite sure what that meant, but that's what they said.